Hi, I'm Bernard Nomberg with the Nomberg Law Firm in Birmingham, Alabama, and we're putting together a series of employment-related videos dealing with the COVID-19 pandemic. In this video, we're going to talk about the Department of Labor's guidance on the Fair Labor Standards Act, and this is geared for employees as well as employers. The DOL, the Department of Labor's Wage and Hour Division, has also issued guidance in the form of questions and answers to many common questions and concerns that employers and employees have under not only FLSA, the Fair Labor Standards Act, but also FMLA, which is going to be a different video than this one. This is all in conjunction with dealing with the coronavirus or COVID-19 pandemic. The first question is, what about pay to non-exempt employees during business closures? Under the FLSA, employers are obligated to pay non-exempt employees only for the hours worked, not hours the employee otherwise would have worked if the employer's business was not closed. If telecommuting or working from home is provided as a reasonable accommodation, the employer must pay non-exempt workers the minimum wage, or at least time and a half of regular pay for overtime hours for hours telecommuting or working from home. Again, for all of these answers, we're going to have a link where you can go to read further in detail. What about paying to exempt or salaried employees, including requiring such employees to use their vacation or leave time without pay during business closures? That's a very common question. Under the FLSA, employers are generally obligated to pay exempt salaried employees their full salary in any week in which they perform any work without exceptions. The FLSA does not require employer-provided vacation time. Where an employer offers a bona fide vacation plan, the employer may require salaried employees to use accrued leave or vacation days as long as the employee still receives payment equal to the employee's guaranteed salary. If an employee does not have enough accrued time to cover absence, the employer must still pay the employee the guaranteed compensation amount in order for them to remain exempt. Employers may not deduct from the predetermined compensation amount for absences occasioned by the office closure during a week in which the employee performs any work. Employers are not required to pay exempt salaried employees in weeks in which they perform no work. What about restrictions on employees who are able to work? Due to increased absenteeism, employers may need to ask other employees to increase their work schedule or perform duties typically outside the scope of their job. Employers may also offer telecommuting as a reasonable accommodation or infection prevention strategy. What about days and hours? How is that regulated? Well, the FLSA does not limit the number of hours per day or per week that employees over the age of 16 can be required to work. Again, employers should be mindful, though, of other restrictions such as whatever your state or local laws wage requirements may be. What about job duties? Employees who are 18 years of age and older may be asked to perform work outside their normal job description. The Department of Labor notes that employers may wish to consult the bargaining unit representation if there's a union contract. Employers may also want to consult HR teams, human resources teams, if they anticipate assigning employees to do other jobs outside of their normal job description during this pandemic. What about the use of volunteer work? Well, private sector employers who are short-staffed may often utilize this type of labor. The Department of Labor notes that the FLSA has stringent requirements with respect to use of volunteers, so be very mindful of this. The DOL notes that, in general, The FLSA covered non-exempt workers working for private or for-profit employers have to be paid at least minimum wage and can't just volunteer their services. Employers that are private and not-for-profit organizations or public agencies may fall under certain exemptions or exceptions and are encouraged to check the Department of Labor rules governing these circumstances about volunteering. What about temporary employees? If an employer brings on a temp employee from a staffing agency to supplement its workforce during a shortage, an employer may be jointly and severally liable for any unpaid wages if the employer is determined to be a joint employer. The DOL recently has revised these, modified these guidances. And for more information, again, we'll give you the site to the website link for you to look at this more specifically. What about offering alternative work arrangements to quarantine employees? Well, employers are certainly encouraged to be accommodating and flexible given this pandemic and things when we've got either a government-imposed quarantine or shutdown. Employers may offer alternative work arrangements, such as telecommuting, additional paid time off, those types of things. However, if there is telecommuting, reasonable accommodations must be provided. What about requiring or encouraging other employees to telework? Well, right now that's probably a very common thing going on with many employers who can handle that type of continuing of work instead of shutting down. An employer really is encouraged or may even require employees to telework, work from home or off-site as a way of preventing or controlling infection. And in doing so, that you can't single out employees because you don't want to run afoul of the equal employment opportunity laws that are out there. If teleworking is not provided to an employee pursuant to a contractual requirement or as part of reasonable accommodations, the employer must pay the employee for the hours actually worked, and it must be at least minimum wage for regular hours and 1.5 times for anything in excess of 40 hours. Employers are still required to maintain accurate records of hours worked for all hourly employees and are encouraged to work with employees to establish the hours of work and when they're worked for the employees who telework. What about reimbursement for telework expenses? If the employee is required to work from home, an employer may not require an employee to pay for or reimburse the company for business expenses of the employer where doing so reduces the employee's earnings below the required minimum wage or overtime compensation. And then lastly, what about telework or home office requirements? OSHA does not have regulations regarding telework in home offices. However, they did issue a directive many years ago that they do not conduct inspections of home offices. They will not hold employers liable for home offices and don't expect employers to inspect the home offices. However, if there is a complaint made to an OSHA office about some type of home office issues, it could be that there is a follow-up investigation made by OSHA. Employers who are required to keep records of work-related injuries and illnesses will continue to be responsible for maintaining such records, even if the injury or illness occurs at the home office. I know this is a lot of questions and answers, particularly dealing with the Fair Labor Standards Act. It can be a confusing set of laws, it can be a confusing time, but we want to be able to help provide answers if we can. Please call us at 205-930-6900 or reach out to us through our website at nomberglaw.com. If you like this video, please give us a thumbs up and tell us why. And we'd like to hear from you if you didn't like the video. We're trying to do our very best here. Subscribing to our channel will ensure that you'll get future videos as they come out daily or weekly. We can also be found other places on the internet, such as Twitter and Facebook.